Hello, everybody. Welcome to, well, what used to be a weekly now is maybe only when it's urgent. And this is indeed an urgent time because what's more important than understanding the developments in de-identification and anonymization? I'm joined today by Khaled El Emam, who, if you are paying attention to de-identification, you know well of Khaled's long practical history, actually as a hands-on advisor and technologist leading and working practically in de-identification, as well as intersecting with the laws and policies globally. I always recommend for those who are looking to get their heads around a very clear, cogent, both sort of technical but correlated with legal structure, the work that he and the team did during his stint recently at the Ontario Data Protection Authority is really invaluable reading, and he is going to help us think through and unpack the recent EDPB draft guidance. And joining me as well, Vincenzo Tiani in our FPF Brussels office. Khaled, I have to start by remembering that pre-GDPR, because we're old timers here, we wrote, you, the lead, with Eloise Garton and I, a paper called something like, here are all the different kinds of pseudonymization or kinds of pseudonymous data, because I think we were hoping that, I think this was the early days of GDPR, there would be an understanding that the debates around where did pseudonymous data fit in were too rigid, that there was a spectrum of different types of activities, maybe some very loose ideas like I'm just, hashing an identifier and then everybody has it. It's a cookie with a million pieces of data and it's sprinkled around. Hey, somebody's calling that pseudonymization. Of course, that's data that de facto is clearly personal. But then here are some very elaborate, techniques that actually are quite protected and indeed are stronger, in fact, than some types of anonymization because of the different measures and limits and so on and so forth. And we said, look, there are options to choose here. And I don't think we really got that reflected. But here, years later, the court has opened the door with the SRB decision. And now we have the EDPB giving us some guidance, around it. So let's jump in. What did the EDPB reflect in opening the door to this notion of pseudonymized data? That's probably the biggest thing. There are other things that happened in this anonymization, guidance, but I guess the biggest thing is that it opened the door to some framing of data that is pseudonymized. It's not fully clear to me where on that spectrum of narrow or tight, certainly on the tighter side, but what's your take of where they've given us guidance that there is a path for data that has an indirect identifier, a longitudinal link, or so forth?
So I think that this new guideline document is a much more pragmatic and practical one than the 2014 document. And the idea of it's risk-based, the contextual approach, it defines two approaches, the simplified and the contextual. The contextual approach is very close to the risk-based anonymization methods that have been used in practice for a long time. The concept of evaluating the risk from the perspective of the data recipient has actually been common practice for a long time. So even if you look at, the HIPAA expert determination method in the US, this is from the mid-90s, made it very clear that the risk is to be considered from the perspective of the anticipated recipient. So this has been common practice, and it's really good that these guidelines reflect that. With respect to the question of pseudonymization versus anonymization, I think the principles still apply in the sense that if you evaluate the risk and find that this longitudinal record doesn't meet the criteria, then it's still personal information. But you do this risk assessment from the perspective of the perspective of the recipient or whoever is going to get the data. So I think that principle applies whether the data is cross-sectional or longitudinal, and based on that determination, you can then decide whether it's personal or not personal.
One idea that I see clearly here, and we were starting to hear this from some of the EDPB staff as we sought to sort of understand the direction of this opinion. And maybe this has been brought in elsewhere, so I'm missing it, but it feels a bit new. One area where it seems like there was a bit of a compromise around the notion of pseudonymous data is whether or not it's actually possible to treat the user differently than other people specifically. And so in a couple of places, it appears that if I'm doing something and the result is, analysis, let me better understand this data set, that is de facto defined as non-personal, while if the purpose, same data, but if the purpose is now, or the capability is to treat this user differently, that defines it as personal, which intellectually bothers me a little bit because it's the same data, but I can understand why practically they sort of pulled this into the definition, consequently making it different, making it possible to treat them differently from other people. So clearly, if somehow I'm targeting, or I have all the arguments that I'm not actually able to identify the user, in terms of a real identity, but I'm somehow able to interact with this user and treat them differently. Now this ends up being captured as relating to an identifiable user. Did you get that in the language? I wouldn't have captured it, frankly, if it hadn't been sort of mentioned. And now as I go through the document, I see that as a kind of interesting political legal compromise.
Just to make sure that I understand, I mean, the thread that goes through this is that the purpose for using the anonymized data has to be similar to the purpose of the original data collection. So that's interesting, and that's potentially challenging in the sense that it limits what you can do with the anonymized data if you want to use it for a very different purpose. So if your purpose is different, then the question is, can you have anonymous data anymore or not? And I think that's a valid question to ask. How do you interpret a change in purpose? Does that invalidate your claims of anonymity, even if you meet the other criteria?
Yeah, I think it's interesting to see how they actually incorporated, aside from the original purpose, they incorporated into the definition. Whether information relates to a natural person, you look at the purpose. If it's information about a person, indirect, and such information is used or likely to be used for the purpose of evaluating, treating, or influencing the status or behavior of the individual in a particular way. And this pops up a couple of other times literally in defining whether they think it is identifiable or not. So right. I thought that there was some creative reasoning happening here that is, but anyway, right. The other big issue that I've been struggling with, and welcome your reaction, is at the end of the day, it appears that if I'm sharing data with a third party, I'm selling it, I'm providing it to a researcher, I'm handing it over, that is, and there is, a pseudonymous identifier in that data set for, whatever practical advantage. That is one situation, and we go through the analysis. But if I have a set of contractual controls with that party, and they are a processor because I'm looking to achieve this for my own use or to facilitate some sort of joinder with another party, which is quite common in the clean room or the other combinations of technology and contractual measures that in the US are quite widespread and some other jurisdictions are widespread. This seems to be an evasion, a use case that clearly they didn't wish to open up. And you get the odd situation where the same data set sold, made public, given to a data broker, given to a researcher, is anonymous data. But if maintained under a processor relationship, because I don't want all those things happening, I just want to facilitate a certain kind of analysis, I read this as sort of taking away all of that because of that clear, and I understand the analysis, right? The GDPR requires the processor to, right, treat the data in that same manner. But it does seem that that takes away a lot of the analysis that in some other jurisdictions opens up a range of data identification under the control of that first party. But I understand that that may not be, there may be more margin to that than I'm reading.
Right. So in the Q&A with that involved someone from the European Data Protection Board earlier this week, that specific question was posed in the context of an organization that wants to anonymize data and use it internally for secondary purposes. So imagine, I mean, I work in health research. So imagine an academic medical center that provides care. So they have personal information and then they anonymize the data and they use it for research. But it's the same organization processing personal and non-personal information. So the question posed was, under the current guidelines, is it possible to put in place separations and controls and meet the criteria, 3 criteria and so on, so that the same organization can perform the analysis on the anonymized data, but still retain the original data? So historically, some DPAs have made the point that you cannot do that. If you own or you have the original personal information, then you cannot have anonymous information under the same roof in the same organization. So the answer to that question earlier this week was yes, you can if you follow the contextual approach, which is described in the guidelines. Then you would be able to have established separations and process the anonymized data within the same organization, which is a really important point because it enables a lot of very useful things that need to happen. And again, I use the academic medical center, hospital doing research example where you want that to happen. You want them to be able to do research on the data. So you can extend that to a processor as well. Why would an organization be able to process or analyze anonymous data internally, but not have a processor do it for them, right? As long as they have the same separations and meet the same criteria, why wouldn't you do that? If you can do it yourself, then can't you extend this as long as you meet the same conditions and so on? So, if A is permissible, then under the guidelines, why can't B also be permissible? It's just an extension. You are giving it to a processor to perform the tasks for you. So there may be a pathway for that based on at least one interpretation of the guidelines.
Yeah, and I'll note that that's also very practical for organizations who perhaps might view their obligation as deleting data rather than retaining it long term, but simply, frankly, want to have a bit of a data lake that enables some sort of retroactive longitudinal analysis. And their decision today is either deleting or reducing the data in a way that really eliminates a lot of utility because it eliminates the ability to have that sort of longitudinal link, that perhaps pseudonymous link. Vincenzo, you were nodding a bit during this particular piece.
Yeah, I was thinking that perhaps, but in any case, I would say the idea is that even if you can, let's say, use it for your own purposes once, say, inside the organization in a separate database, however, let's say, transparency obligation should still be there. So I would say, I would say, like in the SRB case, the Court of Justice said, and it wasn't inside the organization if it was, towards a processor. They said, in any case, under the controller roof, you need to inform the data subject that that you are going to, say, transfer anonymized data. So I would say, in any case, it's important that data subject knows that there will be some processing, even if they will be anonymized.
Our colleague Pablo Palazzi from Brazil says in the comments, what happens if I transfer the pseudonymized or anonymized data to the parent company that is in a jurisdiction that does not have pseudonymous or anonymization rules or prohibitions? What should standard contractual clauses provide? So I think maybe the larger question that Pablo captures, beyond maybe the technical pain of what do we got to do in the contracts, is what concerns have been raised by the role of contractual controls, right? In theory, the SCCs could be simply viewed here as another version of the identification controls, because they're going to guarantee that whatever the status of the data is in another jurisdiction, what will that other jurisdiction... So maybe let's leave the conflict of laws pain for a second, of how will a different jurisdiction that takes a different determination of what is identified or de-identified handle, but he raises the bigger question, which the board flagged, that contractual controls have to always be evaluated in the context of how effectual they are. So, Khaled, I know you flagged when we were corresponding, and I think many others, well, what about the foreign intelligence question, right? So we already have had the challenge of evaluating different jurisdictions around how their foreign intelligence rules work. But the EDPB seems to even be giving us a harder burden. I have to actually know not just what legal oversight exists in terms of limitations on foreign intelligence. I need to know what their the identification cracking skills are, which seems to be an impossibility. And I know many others will file and say, hey, can we clarify a little bit about what it means? But your further thoughts on the role of contractual controls. I think many commentators have made the point that the EDPB seems to minimize it. There's a role, but seems to do a lot to constrain how much you lean on contractual controls as part of the process.
So I'll refer to the Ontario guidelines as kind of a reference for this, a reference that reflects good practices. So the way it's defined there is the contractual controls complement any data transformations. You cannot just have contractual controls. So it's always two things. You apply some data transformations, and then you manage the residual risk through contractual controls. And there's a way to combine both of those in order to make a claim that the risk is very small and you meet the threshold. So you can claim that your data, your information is anonymized. So contractual controls are a complement. And maybe I'm taking a generous reading of the EDPB guidelines, but that's how I read it, and that the contractual controls or the contracts are a complement. It doesn't talk about other types of controls, security controls, privacy controls, in addition to contractual controls. But I'm assuming, again, generous reading is that you can include additional controls in your contract. So you can impose security controls, privacy controls on the data recipient to manage this residual risk and embed them in the contract, right? So I'm putting all of that in the box of contractual controls. So these are described as a complement. And always, when you have contractual controls, you want to make sure that the contract is enforceable in the jurisdiction that your recipients are. So that's a very reasonable thing. So that's how I read it. I think the drafting could be made clearer for sure. And maybe I'm reading too much into it, but the words are there. Is just, I think that it would be beneficial to clarify that point. However, the foreign intelligence, again, from a very practical perspective, we do these risk assessments all the time. I don't know how to evaluate whether a foreign intelligence agency can re-identify a data set. How can I do that? I mean, I don't even know where to start, right? I can make the worst case assumption in that they know everything about everyone, and then no, all data is personal data, but that's not a practical approach. So practically, we excluded intelligence agencies and nation states as potential adversaries because we just cannot do the risk assessment properly to consider that type of adversary. And then the other point I think that's worth making is you have to assume that when you have a contract that the parties will follow the contract. Because if you assume that they're not going to follow the contract and they're going to engage in unlawful activities, then again, how do you assess that? That's just a very large number of possibilities. And if you can't trust the contract, then what's the point? If you have a contract and you say, well, but I have to do the risk assessment under the assumption that this is not going to be followed, and that the recipient is going to breach the contract, then what's the point of the contract? For my risk assessment, I assume there's no contract, right? So it kind of defeats the whole point. So I think these are things that are not practical in the sense that how do I assess the risk when I have to consider those factors? So in practice, we don't. We assume the contracts will be followed. We cannot deal with nation states. We cannot deal with foreign intelligence services as potential adversaries. And that's made explicit in the Ontario guidelines as well. Like the box is, you have an anticipated recipient, you have the contract, and that these rules are going to be followed. And then you have a set of criteria and a framework that you can actually follow, and you can do a reasonable risk assessment under those conditions.
You had flagged. Oh, go ahead.
Yes, I would say definitely it's reasonable to think that contractual provision are, let's say, to be considered in addition to the technical measures, because I mean, anonymization is mostly, say, technical. But going back also following up to the question coming from the audience, if we think about the European Court of Justice that's made void after the Schrems 2, in the end they say something similar, meaning the standard contractual clauses cannot be considered just on paper. So when you do the transfer impact assessment, you need to go through, even if you have SEC don't cover if you don't have a transfer impact assessment. However, it's true that in these guidelines from the EDPB, on one side they say that there's no risk zero and it's fine, but on the others, as you pointed out, the fact that they mention possible attackers, foreign services, even the government itself, for public reason that have access to the data, journalists. The fact that AI agents could be used, for organizing this kind of attacks, that leaves the door quite open. And in the end, if we frame this also these guidelines in the all digital simplification moment that the European Union is going through, there's no way a small medium enterprise can go through this analysis because it's too wide. And so I would say that after the draft, it could be necessary to have some more practical guidance, especially also addressed to SMEs, because otherwise this kind of assessment is not doable.
Well, look, as a longtime practitioner, I'll tell you the reality, right? SMEs today are signing standard contractual clauses because they're being handed to them by their lawyers or by their partners, and nobody is actually doing a global assessment of the capabilities of every foreign intelligence structure in the world. You take a look, and maybe some countries are being commonly ruled out because of what's well known. It's unfortunate, but it ends up being the reality of, well, let's just ignore that part of the law because it's not going to be practically, enforced. It's not the ideal, but the politics otherwise of removing this, when some DPAs probably felt strongly about it in a conceptual way, are what they are. Khaled, you had noted that the no linkage criterion assumes that linking is identifying. And of course, it doesn't have to be, it could be, but it might not be. Can you say a bit more about that?
Yes, I mean, again, you have the kind of simplified process, which is very strict, and then all of that is relaxed later on in the contextual approach. But under the strict process, the no linking criterion basically says, the way it's written, that if you link with another data set, another database, then that's a problem. Then you fail the no linking criterion. But there's two types of linking. You can link a data set with another data set. So say data set A with data set B. Data set A is anonymized properly, and then data set B doesn't have any identifiers in it. It's just more information about the same individuals. So typically, when you link two data sets, let's say they're both anonymized, the combined risk of the linked data sets may be high. The combined data set, the linked data sets, may no longer be anonymized, or it may be. We don't know. So normally, when you link two data sets, you have to perform a risk assessment to determine whether the linked data set is still anonymized or not. Right? The way it's written now is you automatically assume that that type of linking is problematic, but it may not be. So that's one scenario. The second scenario is you link data set A with data set B, and data set B is identifiable. It has the names of everyone and their addresses and their social security numbers and so on. That type of linking is a problem because you're essentially re-identifying the data. So it's not clear which is which and which type of linking is being referred to. So if you're talking about both, they're not equal. One is definitely a problem, and one may be a problem. You have to evaluate the risk in order to assess that. So there's an ambiguity there. And the way it's written, again, for the simplified approach is both are fail the criterion, but under the contextual approach, I'm assuming then you can take the distinction into account and perform a proper risk assessment and decide whether the risk is acceptably low or not.
The number one request I get when I talk to practical researchers or companies is, what's the threshold? Because they don't have a basis, because they can't easily see what others are doing or don't have a good reference number. And they know that the more they add noise or so forth, the lower the utility. So they understand that they would like some maximum utility, but they don't know, is 1%, 2%, a fraction of a percent. They don't know. And it's always a challenge to point to public statistical standards, which do exist for certain sectors, and I think you've helped make some of those visible over time, but they're not commonly and widely known. And I understand why DPAs don't want to, or other experts. It is indeed very contextual. Your particular data set is going to have a different, risk given the types of data and so forth, than maybe even the same type of data set in the hands of a different company, or an additional element. So it's hard to sort of ever put out a number and say this is the number. But the reality is, for the vast group of implementers, there are very common types of data sets, and there are some norms out there, and it would be really valuable if some of those were referenced as no safe harbor, no guarantee, but this is what's considered low risk, very low risk for this sector in this type of use case. Thoughts on how some of those thresholds might be made more visible, given the sort of countervailing factor of nobody wanting to give a sort of, you're now automatically okay as long as you meet this particular number, given that the risk could actually be a bit different.
Right. I mean, I think that having thresholds is really important because it provides the certainty needed for organizations to anonymize. There are thresholds. There are generally accepted thresholds, and typically the thresholds have either a fixed value and then conditions for changing it, or low, medium, high kind of scenarios where it depends on the sensitivity. And the ISO standard, for example, on de-identification, ISO IEC 27559, defines very specific thresholds. But in order to have thresholds, you need to have metrics. So the EDPB guidelines has 3 criteria, but these are not translated into metrics. The criteria are defined at a more general level. If they can be transferred or translated into actual metrics, measurable ways that can be measured directly from data, then you can define precise thresholds on those. There is a body of work that tries to operationalize these 3 criteria and that has defined thresholds for them, but that body of work was not referenced by the EDPB. So I think being able to quantify these concepts by providing some examples at least of how you can measure them and then reference the thresholds that have been used in practice. Some of them have been standardized. Some of them are just de facto thresholds in the sense they're used in practice. That will be extremely helpful because it will provide the certainty needed for organizations to do this, to follow the steps that are needed to anonymize the data.
Before I have Vincenzo wrap us up with sort of like where we are in the process and the broader context, any other key, there's a ton more one can discuss, but for our brief sojourn this morning, any other key points that we didn't make that we should flag?
Well, I mean, I think there's another consideration with the other criterion, which is the no isolation criterion. Again, there's a definition in the simplified approach, which is very strict, very conservative, and will be very hard to meet in practice for many data sets. And then towards the end of the document, that's relaxed. So the no isolation is defined in terms of uniqueness, like sample uniqueness or uniqueness in the data. So if any record is unique in your data, then your data fails the test. But then later on, it talks about the population, because normally uniqueness is measured in the population, not in your data set itself, not in your sample. That's the proper way or generally accepted way of evaluating uniqueness. And that's kind of mentioned later in the document under the contextual approach. So again, reading it generously, you have the conservative approach and then have the practical approach. If that is made more explicit, of course, that would be very helpful. But the simplified approach is really very conservative, and I just cannot see any useful data coming out of that process, except in some exceptional circumstances. I think the contextual approach is the practical one, and if more color and meat is provided around that, that would be extremely helpful. But my general assessment is, look, we're almost there. The document is I think, close. I mean, under the contextual approach, it's close to really providing a practical set of principles. There are a bunch of things that I think there's a chance to provide feedback and in the consultation process, but it's almost there in terms of providing a practical approach that is consistent with current best practices under the contextual approach. Not quite, but it's a really big improvement over the 2014 from the version from the perspective of being a process, a set of principles that talk about a process that can actually work in practice, notwithstanding the points we raised, of course.
But of course, as Vincenzo was going to tell us, this document, which is not yet final, but even when it is final, will not be the final word, because what's the broader context that we need to consider here?
Indeed. So first of all, there's still time for stakeholders to present their comments and views, because the deadline for comments is 30th of October, which is very good since we are in the middle of the summer break. Second of all, because the context is definitely wider in European Union. We are after the AI Omnibus was recently published on the official journal. There's also this very important piece of legislation, which is the Digital Omnibus that regards as well GDPR, and where the European Commission touches upon the real actually definition of personal data, where let's say starting from the Acerbi case of the Court of Justice, in a way, made a representation of the personal data wider and considered that pseudonymous data could be considered anonymous. But let's say in the definition in the original text of the Commission, there wasn't so much, let's say, need to check on the other actors along the chain where data could be used. And this is very important because in the end, either the parliament and the council, so the government, now in their text actually proposed some amendments and narrowed this definition, saying that actually it cannot be excluded, that so that it cannot be ruled out that the third party possesses or can obtain means reasonably likely to enable the data subject to be identified. So in a way, in their view, it's necessary to do a sort of assessment that the third parties cannot re-identify the data. And also they said that EDPB should issue some guidelines, and I think these are the guidelines they were referring to regarding the how anonymization works. So in a way, there's this idea to, let's say, use pseudonymized data / anonymous data for for a better use, especially also for AI training, but also scientific research. But on the other side, there's no will from the European spectrum to actually change the core of definition of personal data.
Let's squeeze in a quick answer, perhaps, to Michael's question. There is a concern that there will be further transfer and the very strong sort of limitations on the concept that if you transfer it on to somebody who can identify it, then that initial transfer is forestalled. Secondly, the third party can identify is not a naive thing. Well, they're not too smart, so they can't do it. I mean, if there are common ways that this can be done, such that some third party, could do it, well, then frankly, you can do it. If somehow there's some unique, ability of some unique, third parties, then we do need to consider that in the initial transfer. Is that a fair response, Khaled, to Michael's concern that there's this transfer to the other party is sort of a sneaky way to sort of get beyond the restrictions?
Well, I think in every data transfer, you would perform a risk assessment, which would consider whether the data recipient is able to re-identify. So you'd apply that in every one of those transfers that Michael is talking about. And so if you're transferring back to the original data owner at some point, and you want the data to be anonymous, or that transfer is supposed to be of anonymous data, then you perform a risk assessment at that point to determine whether it is anonymous when sent back to the original owner, and maybe when you do that, it's not anonymous anymore. Then you wouldn't treat it as anonymous data anymore. So I think every transfer has to be assessed. You can't just do it once and assume, because it's always the whole point is it depends on the recipient. So when you change the recipient, then the conclusion of the risk assessment may change. So the first transfer, you may get an answer. Then there's a second transfer, you may get a different answer, even though it's the same data set.
Let's take an example that maybe, and this is not the case, but let's say pharma companies all had some kind of cross, group identification because of some common research. And when handed to pharma companies who were making such data available to researchers, right? Pharma company could give it to the researchers. Researchers don't have, the key. The data, frankly, could even be made public. It's well, anonymized, but there is a key that the original clinical trial, used, or so forth. Perhaps that key is used across, a few hospitals and so forth. So whenever handed back to those parties, we know that they have the key, while nobody else in the world, has sort of the key for this otherwise well anonymized data. So that might be kind of a very legitimate and practical example that could be relevant in this circumstance. Okay, we are at time. Hopefully we gave folks a bit of a flavor and of the complexity here, and encourage people to file with the EDPB to share particular insights from different sectors that might have some arguments that there are limitations that should be more flexible, or concerns that that need to be forestalled. Khaled, thank you for joining us. Look forward to continuing the conversations on this issue. And Vincenzo, thank you.
Thank you very much. Have a great day. Bye-bye.